It has lots of different topics, but generally it will be discussing First Amendment issues with a lot of the topics we discussed, and then how we can possibly combat a lot of the speech that we heard maybe from AI or deepfakes and other imagery that we heard from the first panel with defamation. And then possibly, if we think that we see a lot of these deepfakes or disinformation, how to label it correctly. If not, it is considered defamation by that point so that it wouldn't be in the future. So with that being said, I'll pass it over to our moderator for this panel, Professor Koo from CASE.
Good afternoon. So as our wonderful Laura, editor, has described this panel. What?
Hey, that's why you need the podium.
My students tell me I never need a mic. Right.
And it's being recorded, so
okay.
I'm not going to project it.
Thank you. Well, welcome back, everyone. And as was already teed up, our panel this afternoon is going to be discussing free speech, and especially from the context of defamation, right? Though, as we go through with our panelists, I would probably say a broader theme would be question everything, right? Which is, again, not a new theme, but certainly an important one, and one to reiterate in our contexts for today. And so my first job is going to be to introduce Professor Mark Blitz from Oklahoma City University School of Law, where Professor Blitz is the Alan Joseph Bennett Professor of Law, and where he teaches ranging classes including free speech, constitutional law, cybersecurity law, and computer law. He is also a series editor for the Palgrave Macmillan series on neuroscience and human behavior. He's going to kick us off with the question of how should we think about defamation and speech, especially artificially generated content, in terms of defaults. Right? Should it be trusted defaults or distrusted?
Thank you. Thank you, Professor Koo. Thank you, Andrew. Thank you all for the hospitality I've received here. So you said question everything. Maybe I could just end early. That more is. Now, let me start. I also gather from the first panel that we don't have 180 minutes, as I misread. It's 18, right? So I'll try to stay within that. But okay, here's what I want to start with. I've written a couple of articles, 2018 and 2020, suggesting, and then when they wouldn't take a hint, arguing more vigorously that deepfakes are unprotected. Deepfakes used for deceptive purposes are unprotected by the First Amendment. So if there's a barrier to regulation, First Amendment free speech law is not it. Today, I'll refer to those arguments, but I want to take a different tack. So this quote often appears in privacy scholarship, articles about privacy. The CEO and co-founder of Sun Microsystems, Scott McNealy, when asked about what can be done to protect privacy, responded this way: you have zero privacy anyway, get over it. Sort of a warning about where we were now 25 years ago, so you can imagine how things have changed. So, using that quote as a template, can we say, in a world where deepfakes are here and getting better, that this is a possible response? You have zero certainty anyway, get over it. To what extent is that the answer? Now, that's not the answer I've defended in the past. That's an answer that's at odds with the argument I've given in the past. But I think it's worth a thought experiment, right? And worth thinking about some reasons why it might be good to build from a default of distrust in a number of different circumstances. Let me say what I mean about it. So what does that mean practically and legally? And first, let me start with a quote that I used when I first wrote about deepfakes, but at that time pushed back against. Right? Someone who was developing a technology to simulate all of your voices, mine, anybody's voice, said, when questioned about the possible harms, look, we want everyone to be aware of this. They'll know the technology exists, and they can show the kind of skepticism that they need to show to survive in that world. And my response at the time is, well, that doesn't stop what Daniel Citron and Bobby Chesney call trust decay in their paper. So that won't work, but maybe there are reasons to think more carefully about whether it will work, and maybe whether it's the only thing that will work. So let me put this on the table. So instead of assuming that video or audio will be treated as authentic recording, instead encourage skepticism. So this is a point that came up occasionally in the first part of the discussion, right? That is, instead of requiring disclosure, a falsity, and otherwise, right, without the disclosure, you can rely on the video, you can assume it's true. Instead, assume it's false unless there's some marker of authenticity, other than its realism. So, false until proven true. So how might that work? A lot of the solution would be technological, right? We have to shift from relying on the realism of video as a marker of authenticity to other sorts of markers of authenticity created by technology. So I'm not going to summarize these, and there are people who know a whole lot more about them than I do, but there are companies developing watermarks. Generally, it's not just a watermark that is identical to the kind of watermark you see on photographs already. It has a technological element. There are methods of using AI to detect AI, or focusing on aspects of videos that it's really difficult to fake that we don't focus on when we look at a video, like visual indications, really subtle visual indications, the way blood flows through the body, or reflections in eyes, or in addition to providing an image, provide a record with the image of how it was created. Right? Now the problem is, of course, this could be faked, and you could sort of imagine infinite regress. So this is a photograph I took of Citi Field. Not that anyone would care, but how would you know it's real? I can sort of provide some sort of technological documentation showing the creation of the photograph. So one example of this from Bobby Chesney and Danielle Citron's argument that I think is intriguing is this proposal for immutable life logs. Right? So people who want to counter a video that portrays them doing something that they wouldn't do, this article says, can subscribe to a service with a company that can be trusted. Right? That's essential to create an immutable life log or authentication trail. So the idea is that will trump a video, even a very realistic video will be trumped by a video that shows you weren't doing what you're shown doing. You were doing this. You're showing doing what the life log said. So so basically, right, a way of summarizing this is we're surrendering, not necessarily now, I don't think now is the time to do it, but possibly in the not too distant future, the frontline defense, where we trust in the realism of video, because it looks like, what I see if I see a video of you, looks like what I see as I look out into the world. And hopefully I can trust my eyes, I can trust that I'm really here, I'm not hallucinating. So I can trust the video, but not in the future, right? Because that's not the way things are headed. So you retreat to some backup method of creating trust. And I'm going to go through this quickly, but again, this is something I considered in other articles in order to argue against it. And it's the kind of thing that philosopher Regina Rini calls an epistemic backstop. Videos now are a backstop. If somebody doubts what you say and says, prove it to me, you can use a video as this more reliable proof. And think about it, right? The world we've been living in, if we hear an audio of somebody saying something on a tape recording, or see a video, we've tended to treat that as much stronger proof than just testimony, just someone reporting something verbal. So the idea is we need a new backstop, because the efficacy of the ones we've been relying on are fading. So another reason to consider this is not just that we're almost at this default of distrust technologically, but more controversially, you could say we're also there legally. Now that might seem at odds with what you're reading and hearing, what you heard in the first part of the panel about all the state laws that are punishing deepfakes. But let me just make a case that maybe First Amendment law anyway applies what I'm calling the default of distrust to deepfakes, and it's this. So Alvarez was discussed in the first part of the paper. Alvarez, I'm not going to take time, because I don't really have 180 minutes, to kind of go into it in depth. But you already heard, right? Somebody lied that they had been the recipient of a Medal of Honor. Xavier Alvarez, he was lying. He was lying about lots of other things at the same time. It was only that lie that got him in trouble, right? That got him prosecuted under federal law under the Stolen Valor Act. And the Supreme Court, in a fragmented opinion in Alvarez, ruled that his lies were protected. There were 4 votes for the plurality by Justice Kennedy, 2 from Justice Breyer's concurrence, so you had 6 votes saying that he couldn't be punished for his lies under the Stolen Valor Act. Justice Alito dissented. But what I've argued in the past is that this shouldn't apply to deepfakes. But if it does, here's why. Let me kind of go over this. The kind of essence of the plurality opinion is that lies are protected unless unless 2 things are true. One of 2 things. Either they cause legally cognizable harm, and one can argue about what that is. Presumably, the lies that count as low-value speech, in defamation, for example, fit into that category. So does perjury, so does fraud, so does impersonating a government official, or one has to satisfy strict scrutiny if one's not in those categories. So this doesn't come out of nowhere. There's a very old quote from Justice Jackson in a concurring opinion in Thomas versus Collins saying, when it comes to speech, every person must be their own watchman for truth. Well, that's another way, I think, of talking about a default for distrust, right? Watchmen are not known for just trusting things to go well, right? Their job is to be skeptical, maybe even be a little bit paranoid. And so if we're going to be our own watchman for truth, that's a suggestion that we're not supposed to just rely on what others tell us. And that's true of speech. And so, you could see why there might be a right to lie under that paradigm. And so what the thing, though, right, is that if that extends to deepfakes, a lot of people, I think, approach deepfakes with the model that a deepfake is kind of a visual lie. And therefore, it belongs on the speech side of the speech-non-speech dichotomy. So when it comes to non-speech, that's not protected. So faking certain things by creating, say, fake evidence, that's not protected. But lying is, and so if videos are lies, deepfake videos are lies, they are protected, except when they constitute low-value speech of some kind. So if you argue that a lie is equivalent to a deepfake, then under Alvarez they're presumptively protected except in these exceptional circumstances, meaning that under First Amendment law you have to distrust them. And the status, I guess we'll learn soon what courts will do with these mandatory disclosure laws requiring creators of deepfake to say that they're fake. But I think if they find that those are consistent with the First Amendment, it will be straining, right, if they want to say that this model is correct. So maybe, right, what I suggested in the past is switch to a different model, right? Treat deepfakes not as a kind of speech, but as a kind of thing in which people place automatic trust. And it's like fabricating evidence rather than speaking in one's own voice. So that's the argument I've made in the past. I'm going to skip over some of these slides so I have time. But one more thing about that argument. So there's, I think, a comparison. If you want to understand the logic driving it, it's helpful to make a comparison with Fourth Amendment law. Right? Under Fourth Amendment law, Fourth Amendment protects you against unreasonable search and seizure. You have a zone of privacy where you can't be observed by government, right, unless they have have a warrant, unless they have some special reason. In the public world outside of it, they have much more freedom to investigate. Now, if, though, your zone of privacy was understood to expand to include everywhere you went, that would disable government from being able to gather evidence necessary to combat crime. So I think, for the same reason I've argued in the past, if you treat everything you can create, everything that technological development allows you to offer as protected speech, that will predictably expand the realm of what's shielded from government by this constitutional force field into territory that we need to be free from manipulation. We need government to be able to protect the sources of our ability to gather truth, free of other people manipulating. So that's the model I've worked with in the past. So what is it? What do we do now? And I have only 5 minutes, so let me sort of fast forward through some of these and consider some reasons why, despite the fact that people are arguing that, look, what's happening now with deepfakes is undermining our crucial assumption that seeing is believing, that we can trust in what we see to an extent we can't trust in verbal lies. Why would we ever change that view? Why would we shift? So let me consider 4 reasons quickly. Basically, under these headings: privacy, autonomy, reality, and clarity. So, privacy-based reason is that this quote, right, you have zero privacy anyway, get over it. Having zero certainty, I think I'm telling you what you already know, having zero certainty counteracts that to some extent, right? It may allow reclaiming privacy that technology has otherwise taken away from us, devastating. So, having zero certainty, less certainty, creates not just a liar's dividend, but in some sense a privacy dividend, right? That is, if, on the one hand, there's this negative effect that liars are protected because they can now deny evidence of doing bad things. On the other hand, if people who would like to invade our privacy want to do it with video, with other data, if it can be faked, then all of us get the benefit of greater insulation, right? And so the idea, I think, is that there's a greater burden that one has to satisfy, other than just showing a video that's realistic. Someone who wants to invade your privacy has to say more, has to prove more, right? They have to use some of the technologies I was discussing earlier, these extra authentication mechanisms, in order to be able to prove that you really did the thing they're trying to show that you did. So it's an added burden, but it might be a good thing. It's not good if it means I have to doubt what's right in front of me, but maybe having to say more, show more, with additional technology is kind of like a sort of privatized warrant requirement, right? We have a warrant to make sure that government cannot enter your home unless they have a very good reason. Similarly, if you make it more burdensome to show that what a video depicts is something that really happened, that may mean that it won't necessarily be always the case that the people who are willing to sustain that cost are people willing to respect your privacy, but it makes it harder. It imposes a greater cost on those who would violate your privacy. Might also further autonomy in a certain sense. In the past, I've said that First Amendment protection for autonomy doesn't allow you to control everything. Doesn't allow you to control others' perceptions. It just allows you to control what's in the space of speech, what's in the space of expression, right? It allows me to tell stories about myself I want to tell. It doesn't mean I can silence other people from talking about me. It doesn't mean that I can prevent other people from learning other things about me from other public sources of evidence, right? But as technology changes, the minimal conditions for exercising autonomy may also change with technology. And if we start to speak, we communicate with video. One more minute. Then it may be the case that a claim I want to make about myself that's believable has to be made not just with stories, not just with verbal accounts, but with video, including video that I create, I shape. So, two other quick reasons. One is that, sort of what I said earlier, if the reality is that what deepfakes have done is thrust us all into really a kind of informational state of nature, a Hobbesian war of all against all. And as was said earlier, maybe law can't get us fully out of this, then you want to adjust to the circumstance as it is, right? Maybe what law should be doing is helping us survive in this state, rather than setting an unrealistic goal of getting us completely out of it. And the last reason, clarity. So I've argued before that deepfakes aren't speech, aren't expression. I get a lot of pushback because deepfakes look like the kinds of things that people express themselves with. They look like movies. Some of these other technological methods they're less speech-like. So one might, if I ask you, is it protected speech to imitate a watermark? Is it protected speech to integrate signs of authenticity into pixels in the picture? I think you're more likely to say no. So it's more likely that this will be found unprotected than video. Okay, sorry.
Thank you, Professor Blitz. All right, now for our second speaker this afternoon, I'd like to introduce Professor Larissa Barnett-Lidsky and Professor. Oh, are we jumping?
Yeah, we're jumping.
Oh, okay. All right. Sorry, I thought I switched it before. So my apologies. So I'm going to introduce Professor Ronell Anderson-Jones instead. Professor Jones is a university distinguished professor and the Lee E. Teitelbaum Chair in Law at the University of Utah S.J. Quinney's College of Law, where she teaches constitutional law, media law, and legislation and regulation, amongst others. Professor Jones was a senior visiting research scholar at the Knight First Amendment Institute and is an affiliated fellow at Yale Law School's Information Society Project. She's going to discuss how, essentially, the promises and pitfalls of defamation law for our purposes today. So, thank you.
Thanks so much to the whole team at the Law Review and the Law School Events Office for inviting and hosting us. I'm learning so much, and I really appreciate the chance to be here and to be a part of the conversation. I wanted to give us a chance to think about what we have learned from the moment that defamation law is having. And to be clear, defamation law is having a moment. To give you some sense of things, when I started as a baby professor, I had many mentors tell me that it was risky or unwise to focus on defamation law, and especially defamation law involving the media, because it simply wasn't sexy enough. Just, not the sort of thing that was ever gonna get you cited in the New York Times. And last year, in just the month of April, by my best count, I was contacted by 76 national and international media outlets for comment. So what happened? Well, most prominently, Dominion Voting Systems versus Fox News happened. It litigated defamatory on-air lies told by Trump surrogates, falsely stating that a voting machine company rigged the election. A second company, Smartmatic, has sued multiple networks and their guests over similar falsehoods. Georgia election workers sued both the Gateway pundit and Rudy Giuliani, alleging that they placed them in grave harm by inventing stories about their mishandling of ballots. The makers of the film 2,000 Mules face a suit alleging they manufactured a reputation-injuring lie about a citizen who says he was merely legally placing his family's ballots in a drop box. A Pennsylvania postmaster sued, claiming he was swept up into defamatory disinformation, falsely characterizing him as part of an election tampering plot. A top county election official in Arizona sued politician Carrie Lake, alleging she invented harmful lies about his action on the job. The list goes on. And if we add to this the steep uptick in defamation cases, not directly about election lies, but still squarely impacting elections and politics. Think Sandy Hook parents and Alex Jones, or E. Jean Carroll versus Donald Trump. The effort to use defamation as a pro-democracy, anti-disinformation tool is visible all around us. So I'd like just to pause for a moment of assessment and explore some ways that libel law has been a good and a poor fit in this new role of combating election disinformation. And I think along the way, the exercise might help us see the ways that we remain vulnerable and the ways that we can prepare for future litigatable lies, which I am sorry to report are here. Okay, on the pros and cons, let's start with what we might put over in the pro column. The obvious major upside here is that these suits are bringing some consequences to overt spreaders of damaging falsehoods in the public sphere. Indeed, I think if you survey the sort of legal and non-legal efforts aimed at bringing accountability against some of the big-name repeat actors in both the media and the highest political spheres for their democracy-harming lies, defamation is the only tool so far that has gotten the job done. It deals with that problem with real effectiveness, with juries of peers, with relative timeliness. Importantly and surprisingly under-recognized, these bad actors are quite literally what the incredibly speech-protective standard from New York Times versus Sullivan was designed to buffer against. With its hard-to-meet actual malice standard, Sullivan famously discouraged defamation as a tool wielded by public officials and figures, preferring instead sort of robust, wide-open debate and tools of public information and education and counter-speech over the democracy-damaging prospect of government leaders or other important figures kind of suing to silence and punish their own constituents. But it clearly delineated as an outer boundary to this overarching value the need to protect these folks' reputations against knowing falsity or reckless disregard for the truth where there was this high degree of awareness of the probable falsity of the statement. That is, fully made up lies that were obviously harmful to reputation and well-being and were being peddled deliberately with awareness of their inaccuracy. Over the decades, Sullivan came to be seen as a virtually unclearable bar, but it is probably more accurate to say that we simply did not have the same scale and scope and seriousness and shamelessness of invented falsity about public plaintiffs as we have seen in this recent spate of cases. So if we're tallying what has been gained in this kind of tsunami of libel cases brought with some aim of remedying wider harm to the democracy, it is no doubt substantial. It's the one venue in which truth is still the very explicit goal, and it is ascertainable and it is announced. Distrust in key election areas gets combated, and at least potentially it acts as a corrective on those incentives for public service. And while this has become especially salient during the Trump era, he is actually probably best seen as both a symptom and an accelerant of the problems that these cases are tackling. The point is, whether you think that we need to be fixing the mess that Trump created or fixing the mess that created Trump, we are unquestionably in a place where this confluence of political, economic, technological, and societal changes surrounding our communication have thrown us into this epistemic chaos. Hannah Arendt prophetically forecasted that when we're robbed of the common facts that are necessary for shared conversations, we imperil democracy. And I think that defamation law has proven itself able to sort of suture at least some of our wounds on that front. But I have 4 quick sets of observations to place over in the other column, trends that I've given not one bit clever labels to, but that nevertheless deserve our attention and warrant our caution as we're as we're celebrating this tool's effectiveness on a lot of fronts. The first is what we might call the problem of doctrinal dilution. So with this wave of cases seeking to solve problems much larger than the reputation of single individuals or entities, comes a great deal of pressure to make defamation an easier tool for plaintiffs. Some are so keen to beef up this instrument for countering lies that they might lose sight of the more complicated ways that democracy preservation and defamation intersect. We saw this in a lot of the discussion on Fox Dominion, where some commentators' outcome preference, right, for Fox to be held accountable for peddling lies, really got in the way of their support more generally for full-bodied speech protective measures in cases involving public figures and speech on important public matters. And conversely, I think we see this in the position, which I find dangerous, taken by Justices Thomas and Gorsuch, that Sullivan should be watered down to better protect against disinformation. This is a place where we have to work incredibly hard to curb some of our initial instincts and to, go mild, not wild, and recognize that allegiance to principles of democracy preservation actually demands that we not make these cases easy to bring or win. Defamation law is a lethal tool for those who have anti-democratic tendencies and who wish to weaponize opportunities to punish their critics, to threaten dissenters, to denigrate non-loyalists. This is what autocrats do. They threaten and scare people into what Timothy Snyder at Yale has dubbed anticipatory obedience. They use defamation law to make both associates and ordinary people fear retribution if they speak up or hold the powerful accountable, or even merely get in the way of a narrative that the autocrat has designed. And critics of Trump have emphasized that defamation law is, by all accounts, including his own, a primary mechanism by which he would aim to dismantle the American press as we know it. In a piece from last week that I cannot recommend strongly enough, the publisher of the New York Times describes the playbook used in Hungary and India and Brazil, which he says he and his team have watched Trump attempt to apply in the US as well, involving demonizing independent media, harassing news organizations using defamation suits, and harnessing allies to amplify that legal harassment so as to ensure that pro-regime communications flood the airwaves. And the upshot here is to intimidate the press by suing them for defamation over even minor error, and thereby sort of making it easier to act in authoritarian ways without necessarily dismantling the formal mechanisms of democracy. Instead, amping up the use of some of these tools, like defamation law, that we already have at our disposal, but can be easily harnessed for anti-democratic, anti-independent press purposes if the constitutional guardrails are lowered even just a bit. And historically, the death of a free press that is able to criticize the governing regime is an extinction event for democracy. So I think that we have to be incredibly vigilant, even while acknowledging defamation law's obvious usefulness at a time of a disinformation crisis, that we not allow it to spur this dangerous doctrinal delusion. Okay, second is a concern about what we could label non-defaming deceivers. Because of its recent successes, there's a tendency to herald defamation law as the cure-all for all of our disinformation woes. And the simple reality that seems to get lost is that most of the problematic disinformation at the core of the crisis that we are discussing today is not itself defamation. Huge swaths of rampant lies that have caused the greatest concern in recent years, falsehoods about elections themselves, but also about things pertinent to elections, like medical treatments and vaccinations and climate change and behaviors of minority groups and so forth, are not attacks on the reputation of any identifiable individual or entity. They lie, to be sure, but they do not defame. And when a widely shared social media post broadly claims the election was stolen, there's no obvious reputational attack at issue and no basis for a libel suit. So while these fast-spreading lies are polluting public discourse and they are inflicting harm, they're not inflicting harm on reputation, and that's what matters for purposes of defamation law. So there is some overlap between them. Sometimes, just ask the poll workers and election officials and postmasters who are plaintiffs. But there's no reason to believe that disinformation as a wider phenomenon is going to serve itself up in a way that merits a defamation claim. And indeed, significant research in the area suggests that it often does not. So we have to address the wider problem of these non-defaming deceivers. Third, I increasingly have concern about a phenomenon that Larissa and I have casually between ourselves referred to as, and it might not be the right title, delusional defamers. It maybe carries a little too much. Okay, but here's what I mean by this. There are people, including people with quite significant followings and platforms for their speech, who are contributing in massive ways to this problem of election lies, but are differently situated from the tellers of deliberate falsehoods who've been the defendants in some of our most high-profile cases. because these lie tellers genuinely think they are telling the truth. And actual malice, that Sullivan standard that requires knowledge of falsity on the part of the perpetrator of the defamatory lie, is a subjective standard. It climbs inside the head of the teller of the lie and asks whether they in fact knew it was false when they spread it. And in cases like the Fox News case, where we saw this evidence in the motion for summary judgment, the network's own internal communications, right? Their memos and emails and text messages saying this source is crazy, or this election obviously wasn't stolen, or we see people gravitating to other networks that embrace these conspiracies, so we should platform the lies to feed that appetite. That's great evidence of actual malice. But the case is potentially much harder when it comes to someone like, to pick just one example, Mike Lindell, the MyPillow guy, who has been named as a defendant in a number of these so-called big lie election defamation actions. And the record in these cases strongly suggests that he spouted a significant amount of extraordinarily harmful and objectively false bile about the election being stolen. But there also seems to be a not small amount of evidence that he himself is fully, although delusionally, completely convinced of it. And the doctrine knows how to handle speakers who know a truth and insist on a lie with brute force. But those who may be part of terrible conspiratorial falsehoods while not fully or even partially realizing it, they're less accounted for by the current rubric. So yes, there is enormous moral culpability in that ignorance, much of which might itself be willful, or at least the result of a set of choices about what information they seek out or take in or credit. And the downstream consequences of their lies to audiences are obviously grave. It's possible, I think even likely, that the reckless disregard for the truth standard will need to develop nuance to deal with this phenomenon, but at the moment, that standard requires a high degree of personal awareness of the probable falsity of the defamatory statements. So we're actually going to need to incubate some scholarship on this front. And then we're going to need the courts to confront this increasing reality and to, grout the doctrine in ways that sensitively address that gap that I expect will become increasingly pertinent. The problem that's created by these delusional defamers. Lastly, and perhaps most troubling to me, is the problem that I've labeled undeterred defamers. We have this severe cleavage in politics, a calcified electorate with a potentially historically large percentage of people of both ideologies in the population, seemingly conditioned to demand unequivocal proof before they'll change an opinion that was formed on no proof at all. And we have this once shared media ecosystem that has essentially been bled dry by a toxic combination of platform-induced economic harm, an active vilification from political actors, and the quite foreseeable doom loop of journalists who are stripped of resources and then inevitably produce poorer work product, which then reinforces and backs up the criticism against them. And I think it becomes increasingly easy for powerful people to take advantage of the fact that everything looks suspicious when you don't know how anything works. And they become deeply incentivized to preemptively convince followers that an election won by anyone but them is inherently illegitimate, and to cast we the people as an exclusive, not inclusive category, and us defined against them. And so robust is the audience for this kind of communication that we've seen this stark break for some of the really baseline defamation deterrence presumptions of the past. For most of the long history of defamation law, a jury determination that material was false and defamatory settled the question. Defendants facing that liability would take every possible step not to repeat the lie, both because it would be socially reprehensible to do so and because the risk of punitive damages was a powerful deterrent, unlikely to be overcome by some stronger incentive. In short, defamation law used to stop defamation. But recent cases have scared me because they feature defendants who seem motivated to defame even as their assets are depleted or made unreachable to plaintiffs. So we have examples of people repeating the defamatory falsehood out on the steps of at the moment that the jury is deliberating, using it as fundraising mechanisms. We saw this with Giuliani, we saw this with Alex Jones, we saw this as recently as last week as Donald Trump, who repeated the already adjudicated defamatory lies about E. Jean Carroll, repeated them and has vowed to continue to repeat them. And what we're seeing, I think, for the first time, is sort of a lack of surety that the foundations upon which our defamation doctrine is built remain intact. And these situations seem to fly in the face of some of our core assumptions about defamation law, that it can remedy reputational harm, that it can correct the public record, that it keeps defamers from continuing with lies. It's a doctrine that assumes that defamers will choose truth over the prospect of future damages, but it also assumes stuff about audiences, that we won't want to continue to be served up adjudicated lies. And if we've entered into an era in which the incentives to spread lies for politics and profit are so strong that these damage awards and settlements might not meaningfully change behaviors, we're in need of much larger conversation. Defamation is a supply side tool, and I think we have a serious demand side problem. Now, I famously, almost naively, have quite a lot of faith in the American experience, and so I don't want to end with catastrophizing the set of problems in this space, especially because my close observations in this area teach me that many of those successes that I talked about at the beginning have buoyed up and energized a lot of people who are working hard to talk about the ways that truth and reputation and healthy civic discourse travel in tandem. And the positive spin on this is that if defamation law really is like the canary in the coal mine for the wider rule of law, I think the takeaway may be that, there are like some faint audible chirps that things are going to be okay. A postmaster and some poll workers and these voting machine companies are pushing back against what they think is noxious election disinformation. And they're not even hinting for a second that the constitutional protections for free speech should be eased. Just that their own cases clear the appropriately high bar. And I think this suggests that if we are willing enough to engage the nuances and tussle with the hard questions, we can do a lot of way paving in defamation law. In any event, I think that it does turn out that it is a sexy topic after all. So thank you very much for your time. I look forward to our conversation.
Thank you very much, Professor Anderson-Jones. And now I'd like to introduce Professor Larissa Barnett-Lidsky. Professor Lidsky is the Raymond and Miriam Ehrlich Chair in U.S. Constitutional Law at Florida Levin College of Law, where she specializes in defamation and invasion of privacy, internet speech, and constitutional law. These are all my people here on this team, so it's very great to see you all in person. She is co-reporter on the Restatement of Defamation and Privacy, and for all of you who are inside baseball in defamation, has succeeded Judge Robert Sack as the author of Sack on Defamation. So Professor Lidsky will discuss what she describes as fault-free generation and how that works with defamation. Thank you.
Okay, so in order to fit more in line with today's topic, I changed my title a little bit to Defamation AI and the Nature of Truth. And I asked Ronell to switch with me and go first because I know sometimes it seems like we have the Vulcan mind meld, and I wanted to make sure I didn't repeat too much of what she said, but you will hear some familiar themes from me. So defamation law, of course, has been offered as a tool for deterring willful disinformation, reckless or negligent misinformation, and making sure generally our public discourse maintains its anchor in truth. Recent cases suggest that overall defamation may be doing a relatively poor job in the election context. There's some successes, but also there's some reasons to be cautious. For example, although the election workers in Georgia did win their suit against Giuliani for $148 million, Giuliani promptly turned around and declared bankruptcy. We're still seeing how that's going to work out. So in terms of compensating them for the death threats and the harms that they faced, we don't know what's going to happen. And Giuliani, meanwhile, promptly turned around and sued President Biden for defaming him. Biden had called him in the debates a Russian pawn, and that suit got dismissed yesterday. Dominion versus Fox, biggest libel settlement, $787 million. The judge ruled that they were lies, and to avoid the shameful display of witnesses on the stand, perhaps, that the trial might evoke, they did settle that case for a large number. It barely set them back at all. They had 1/4 of profits that were down a bit, and they've popped right back up. Smartmatic is suing Newsmax. Newsmax has said this is a Bet the Ranch lawsuit that they may go under. They're not as big as Fox. They may go under if Smartmatic wins its lawsuit. The judge also has ruled that the information is false. In the meantime, Smartmatic, one of their founders and 2 employees have been indicted by the Justice Department for trying to bribe Philippines officials to put their voting machines in place to get the contract on that. It's not good for the lawsuit, just to state the obvious. Smartmatic is also suing Fox. Carroll versus Trump and Trump versus Carroll, Eugene Carroll. Okay, Eugene Carroll had to sue Trump twice because, as Ronell said, he is a repeat player as a defamation defendant. Even after it was been found that what he said was a lie, he decided to repeat it. But then not only that, he sued Eugene Carroll for saying a jury found that he raped her. Under a technicality, it found that I'm sorry, I'm going to be graphic here because it's necessary for the case. In New York law, rape requires penetration with your penis. He was behind her. They found that he had sexually abused her in a way that likely they believed she wasn't sure if it was his penis or his hand, and therefore they did find him liable for that. And so the difference between that and rape in common parlance is not very much. The judge dismissed the suit against her, but Stephanopoulos also sued for using the term rape there. And here's my point. Here's my point about defamation law. This series of back and forth is part of my point about defamation law maybe not being ideal for combating some of the kinds of disinformation we need to combat. And that is this. Defamation lawsuits are themselves sometimes tools for spreading disinformation. Defamation lawsuits have become a form of political theater. And I will give you an example from this week. I was called about a lawsuit by a company called Express Scripts, Cigna Express Scripts. The FTC wrote a report about Cigna saying that they were overcharging for drug prices, that pharmacy benefits managers result in too high drug prices. They filed a defamation lawsuit against the Federal Trade Commission and Commissioner Lena Khan. And when you read the complaint, as is fairly common these days, the complaint doesn't read like an old-fashioned defamation complaint. It reads like a press release because that's what it is. It's designed to be quoted in the news media. That's all it's designed to do. There's a claim for defamation that really is suing for things that are either opinion or that are certainly covered by sovereign immunity. These suits are going nowhere. There's also a claim that the FTC has no authority because Article 2 of the Constitution was violated based on the removal authority of the executive branch over Lena Khan and the commissioners on the FTC. Not even kidding. But the lawsuit is not about what it claims to be about. It's really about a contestation in the marketplace of ideas of bad publicity from a government agency action. Okay. Point number 2, another reason, Ronell already said this point, but I want to amplify this point, is if you're counting on defamation law to combat misinformation and disinformation, you need to think of a Venn diagram with a really tiny subset in the middle of it of reputation-harming disinformation, or reputation-harming disinformation of the kind that you can bring a defamation suit for. And I think here in Ohio, you have a really good example of that. The Haitian pet eating story. I could say more. Do I need to say more? I don't think I need to say more.
Group libel.
Yes, group libel, yes. Let me say the rule on this. Groups cannot sue for libel. So all Haitians can't sue for libel. So this kind of leveraging of the worst forms of dog whistle anti-immigrant sentiment, there's nothing in the world defamation law can do about that. We in our communities have to have to do something about that. And then another thing, Ronell mentioned this, but I want to amplify it as well and perhaps say it in a slightly different way. Even seeming victories for truth in defamation cases don't change public perception and reset our discourses anchored in truth in the way that we think they're supposed to. And it was mentioned earlier that there are a lot of people, entirely on partisan lines, who think that the election is stolen now, who didn't necessarily think it was stolen 4 years ago because of the repetition and the repetition and the repetition. And it's part of a broader phenomenon, right? So it's a phenomenon of discredit brought on many of our public institutions, including courts and juries. People don't trust courts. They think everything courts do is political. They think a jury verdict about whether Trump did or did not sexually abuse E. Jean Carroll in a dressing room is just political. They think everything is lawfare. So that's a discrediting of our judicial institutions and the rule of law that we need to be uber concerned about, in my opinion. It's a discrediting of the institution of the press. All press is biased, particularly, you can discount the liberal press, you can discount the conservative press. I think this is a bipartisan issue. I see people on each side only believing their own side's agenda. It's partly distrust of the executive branch and the executive manipulation of the information ecosphere. By the way, I'll say some of this distrust in all three categories, the judiciary, the media, and the executive branch. I think some of the distrust is highly warranted. But nonetheless, if you're talking about the nature of truth in this country, then it is worth noting that this is part of the reason that defamation lawsuits won't save us even when they have an authoritative declaration of truth. Or Ronell had a really nice description of it that I wrote down, I can't quote, but about accountability. What'd you say? Three adjectives that were good. It's an open, accessible declaration of truth. And the other thing is, the Fox case demonstrates this nicely too, is because of the demand side problem for lies, sometimes lies are more profitable than truth. So there were people within Fox who knew that the election was not stolen and made a choice to keep putting Giuliani on there, keep putting, what's her name, the lawyer from Texas on there?
Sidney Powell.
Sydney, our friend Sydney Powell on there, because their viewers were deserting them and going to places like OAN and Newsmax because they didn't want to hear the truth. And so they're like, okay, we know this is false, but we're going to lose market share. We're going to lose our audience if we don't tell them the lies they want to hear. Okay. Now, into this, that's the backdrop. Into this comes generative AI. And we've talked about some of the issues of generative AI tomorrow. Scholar Eugene Volokh has called generative AI large language model a large libel model, but they're also potentially large misinformation models. And I really, right now in my writing, am focusing on the misinformation problem. Okay, they're already undermining the nature of truth in this sense. Candidates are discounting truthful information by saying it's AI generated. But in the meantime, there's a risk that untruthful information generated entirely by the AI itself is going to pollute public discourse. And so what I'm working on lately is how do we adapt defamation law to the problem of misinformation, not willful, generated by a non-human actor. And the first case is already upon us. By the way, I will note for your delectation that the mission of OpenAI is to ensure that artificial general intelligence is used to benefit humanity. Very noble, right? Very noble mission. Okay, but here, that's the mission. The reality is a little bit different. ChatGPT, how much time do I have? Okay, good. Oh, excellent. So ChatGPT falsely accused radio host Mark Walters of fraud and embezzlement in response to a query by a journalist named Fred Reel. He was researching a gun control statute and the constitutionality of it, and he knew this area really well. He was a little bit surprised, so he said, really? He said, give me some evidence. So he produced a complaint. totally invented with a fake case number saying that Mark Walters was guilty of fraud and embezzlement. And how does this happen? It can happen in two ways, and our liability system might have some need to adapt to the two ways it can happen, primarily two ways. One is generative AI is trained on thousands and thousands, millions and millions of documents, endless trove of documents. And so sometimes it just picks up things from documents. It can create copyright problems when it unduly just recreates verbatim. It's a pastiche or a collage of things it's gotten from other places. That's one way it operates. And so if it does that, you can go back to the original source perhaps and say, oh, that's defamatory. But the other thing it does, and this is what happens in the Walters case, is it's a prediction engine. And so it predicts words that are likely to be strung together. It turns out Mark Walters is a Second Amendment rights advocate. He's a radio host and he does a lot of that. And so they predict words that might be strung together related to Mark Walters, things he said, and that's how they ended up with this fraud accusation. And the irony of this is the truly big public figures, like a celebrity, there's likely to be enough documents in the millions of documents that actually that kind of hallucinated falsity is less likely. It's more likely to fill in its prediction wrong for people that have some online presence but not a whole lot. For example, when I asked it about my own bio, it said I went to law school at the University of North Carolina. Great school, but I didn't. Okay.
UT would like a word.
UT would like a word. Now, the thing about these hallucinations that we need to worry about in the defamation sphere is they can't be eliminated entirely. Though different design choices can make them less rare, they're getting a little better over time. And the user temperature setting on how they set the AI also makes a difference on how much they're going to hallucinate. But they're really prevalent, at least 3 to 10% of the time they happen. I've had it produce entirely fake Supreme Court cases for me. That was fun. And Eugene Volokh had suggested a takedown remedy is adequate, but it's not even clear you can really take it down because there's a black box theory about how it happens. It's not entirely clear you can get it entirely down in every case because they don't really know how it happens. And fault-based defamation law is not up to the task, but never fear. Okay, so in my work on the restatement, I have been writing about the evolution after New York Times versus Sullivan in 1964, the evolution in the common law from strict liability tort to a fault-based tort. And the reason for the shift to a fault-based tort is the idea of the inevitable error. And you're saying, okay, Lizzie, that sounds exactly like what this is, the inevitable error. But this is not the kind of inevitable error that the Supreme Court in New York Times versus Sullivan was trying to protect. The kind of inevitable error they were trying to protect was a journalist working on a deadline, talks to witnesses, gets a story, it's super important story, needs to go to press. There's some risk that they will have trouble proving that when it comes down to it. If every little technical error leads to a defamation lawsuit, then there's a fear that they won't be as robust in reporting on public information as they need to be. And so we protect lies, yes, but we only protect lies to make sure that we don't chill those errors that are inevitable if we want to have robust coverage of important and newsworthy information. So it's rooted in the chilling effect, our fault-based defamation system. So the story after 1964, and I'm not going to be able to tell it in full, but is that fault-based conception got built into the common law, not just into the constitutional law, but into the common law. I've got the 50-state survey to prove that to you. Do we have to have that in the case of liability for OpenAI itself? And I would argue that the answer is no. Okay? I do think we need to have protections designed for innovation, and there are First Amendment interests attendant to the outputs of OpenAI. I agree, along with most commentators, and I'm going to finish in 1 minute. Tony Massaro, Helen Norton have written really wonderful things in this area. Cass Sunstein, Stuart Benjamin. and all agree that the outputs of generative AI can be really useful to the audience. And so the right to receive information is an important First Amendment right. But of course, it's mainly important in terms of democratic self-governance or the search for truth if that information is actually truthful. And of course, generative AI has no autonomy interests of its own, and the protection for lies need not be, they're not even lies because they're not willful. The protection for this misinformation that is the product of hallucination need not be as robust as it might be in the defamation context, as if there were a human speaker. I have all kinds of ways where I would protect innovation, but nonetheless, I'll say that if you have any questions, I'm happy to answer them. And I'm so honored to be here today. This has been such a wonderful symposium. I just feel very, very lucky to be here.
Zalitsky. And now our final panelist is Professor Ellen Goodman, who will be joining us from Zoom. Professor Goodman is a distinguished professor at Rutgers Law School, as well as co-director and co-founder of the Rutgers Institute for Information Policy and Law, where she teaches, among other things, information law and privacy, algorithmic justice, free expression, and civic media. Professor Goodman will also be discussing with us today the benefits and challenges associated with treating synthetic content as trustworthy versus untrustworthy. Thank you.
Hi everyone, can you hear me okay?
Yes.
Yep. Okay. Really sorry I can't be with you. I'm stuck in Washington. So let's see. Is my screen, is my presentation showing?
Not at the moment, but we can get it fixed.
Oh, okay. Let me see.
Maybe a very minimalist presentation.
Still don't see it.
See the Zoom screen?
Ellen, now it's showing, but in split screen. We're just seeing your presentation mode, not your presentation mode.
Seeing it now?
Yes.
Nope. No, okay, so I need to.
Left PowerPoint. All right, now you're back.
Now I'm back, all right, I'm just gonna leave it like that. And is it in presentation mode? No.
No. You should start slideshow.
No, I know, I'm just trying to get, working?
Yes. Perfect.
Yeah, okay, let's go. All right. I'm sorry I caught a little bit of the last presentation. I think this fits right in. We're going to jump right into Gen AI and synthetic content. So since Gen AI burst on the scene in late 2022, policymakers in every Western capital and in every US state have been anguishing about the coming epistemic storm. I know you've all been talking about it, where ground truth recedes in a haze of synthetic content. NIST and the White House define synthetic content as information that has been, quote, significantly altered or generated by algorithms, including by AI. And one of the responses to come out of these worried capitals is transparency. The EU AI Act and other proposed and adopted interventions would mandate synthetic content detection, labeling, and watermarking. Transparency, it suggested, can mitigate the discursive harms that can result from synthetic content, whether this is deception or more generally confusion about what is real. And while I myself have worked on these policies and have been a big proponent of transparency, I've come to conclude that mandated detection and disclosure policies which default to authenticity are incoherent, possibly counterproductive, and legally vulnerable. So this says nothing about the utility of forensics and synthetic content detection research and development outside of legal mandates, which is very valuable. So what I want to do is just quickly give you a sense of what some of these synthetic content policies, disclosure policies look like, and then surface some of the risks entailed in defaulting to authenticity. And I'll conclude by suggesting instead that policy work should adopt a default to distrust and help develop and enable authentication systems as a more coherent, scalable, and legally sound approach. And I'll try in doing this to highlight some of the specific election communications implications, but the points are really more general. There are lots of different kinds of synthetic content harms, and sometimes I think the discussion confuses them or melds them all together. And I just wanted to start out by distinguishing them, because I think that they fall into importantly different legal buckets. So there's discourse harms. There are discourse harms, which are mis and disinformation, and that has implications for, in addition to democracy, for national security and the economy, etc. Then there are dignitary harms. Two central ones would be non-consensual intimate imagery, such as the Taylor Swift deepfake, digital child abuse, and reputational harm from digital replicas of art. Digital replicas of art also have imposed economic harms, and then there are the other main bucket of economic harms would be scams from voice clones and other kinds of deepfakes. Perhaps the most severe kinds of harms are the long-term downstream epistemic harms. These result from recursive training of AI models on synthetic content that can lead to model collapse and just an accelerated drift from ground truth. The discursive harms, kind of when they all flow downstream and puddle together, they create a kind of information epistemic haze or information pollution, which is harmful. And the reason I separate them out this way is because the legal responses are quite different, and I just want to make clear that I'm only talking about disclosure. For dignitary harms, there are other, disclosure doesn't help much with dignitary harms, and there are other tools in the toolbox, including bans, which are becoming increasingly common. We're seeing in the states. Iowa has one, and they're proposed in a bunch of states. Also, there are federal proposals. There's tort liability, new forms of publicity rights and IP rights. Those also help on the economic side. There are new kinds of, there's existing consumer protection law to deal with scams and new proposals and new enforcement strategies. And then the epistemic harms, sort of all of the above, plus some of the AI existential harm, sometimes called the doomers. Some of those strategies deal not just with the end of humanity, but also some of these epistemic concerns are also in scope. So, for example, model transparency, red teaming, AI auditing. Those are targeted at other problems, but also include sometimes some of the epistemic problems. Okay, so for the rest of this talk, I'm going to be talking about the discourse harms and disclosure. So two episodes in the election context have garnered a lot of attention, and I'm sure most of you are familiar with them during this presidential election season. One was a political operative synthesized Biden's voice and told people not to vote in a robocall in the primaries. Second one, more recently, Elon Musk amplified on X a synthetic video of Kamala Harris calling Biden senile. And these two examples show a range of policy tractability, with the telecoms networks being more amenable to control, and the FCC has a rulemaking on this, than pure internet applications where there is no regulator. Not all synthetic content harms in the election context come from deepfakes. Alondra Nelson and Julia Angwin have a really good report that produces evidence of hallucinations from Gen AI providing false information about voting. I will say that the discursive harms are a concern, for national security. Folks worried about destabilizing information warfare. We've just seen this recent Justice Department announcement. And other parts of the government are worried about the credibility of government data releases, on the economy, et cetera. So, which is just to say that there is a big constituency in the federal government that's concerned about this for reasons apart from, the sort of democracy reasons it concerns that we're talking about today. So policies to address synthetic content, discourse harms, encourage or mandate watermarks, metadata, or provenance and or labels, all of which can be machine or human readable. Platforms like Meta, YouTube, and TikTok have undertaken to do this voluntarily with the usual spotty enforcement. The inadequacy of private actions has resulted in a flood of legislation or proposed legislation and other kinds of interventions. So last year, the Biden-Harris executive order on AI requires the federal government to work on technologies and to implement practices that track provenance and legal synthetic content, as well as authenticate content. More about that later. NIST is taking the lead and is addressing synthetic content harms, focusing on disclosure. DoD and Homeland Security, because they do have these interests, have projects developing synthetic content detection and provenance tools. Lots of federal disclosure bills. They focus on electioneering, deepfakes and digital replicas, and on synthetic content writ large. Some states have passed and many have proposed laws that require synthetic content labeling. Starting with the granddaddy is California's 2019 bot disclosure law, and then the recently tabled law in California, AB 3211, which would have required AI systems to apply provenance data to synthetic content. And other states are focusing their efforts specifically on election communications and fraud. I think in the interest of time, I'll skip discussion of the interventions abroad, just to say that they are either strongly encouraging the labeling of deepfakes and other synthetic content or requiring it. So I pulled this together to specifically address the election-related labeling interventions. The federal laws are all just in the proposal stage. State laws, and these are just some, I think 19 states have adopted disclosure laws for AI-inflected or generated electioneering content. And I guess that just will say that sometimes they're framed as a requirement of disclosure. Sometimes disclosure is an affirmative defense to a new crime of using deepfake technology in electioneering ads. California has just passed a new law, AB 2655, I think last week. It was signed into law requiring large online platforms to remove or label deceptive and visually altered or created content related to elections during the pre-election period. And both candidates and public officials can get injunctive relief. Okay, so now let's get into it about what the heck is synthetic content and how do we understand authenticity in relationship to it. Generally, these instruments define synthetic content as content that has been manipulated, altered, is AI generated, or machine made. I mentioned the US NIST definition. The EU AI Act defines it as output that has, quote, been generated or manipulated by an AI system and not a human. And it tries to exclude common editing technology from the definition. Other terms used in legislation are deepfakes or digital replicas. And notably, whereas the synthetic content definitions just require alteration of some input to qualify, the deepfake definitions turn on misrepresentation or falsity. But there's variety in the degree or materiality of the deception that the laws care about. The kinds of disclosure contemplated by these laws, as I said, are labels, provenance, and watermarks.
So just very briefly, labels are human-readable indications of synthetic content that can be affixed upon content generation, or more likely by the distribution platforms or other intermediaries. Provenance legends are a little more, sometimes they're called nutrition labels for data. They are metadata embedded in digital files, digital media files, or stored separately in databases that are cryptographically secured. The metadata can really, deal with any characteristic of the media that's important to the creator, specifically for our purposes, source, alterations, modifications, ownership, and then kind of the distribution pathway. It answers questions such as who created this content, where, when, who owns it, how has it been modified or shared. Watermarks, you can see that little circle in the bottom right of that, are visible or invisible perturbations of digital media files to indicate their origin, and in these policy instruments, most often the term watermark is used to refer to a source identifier for a Gen AI product. Okay, so authenticity is sort of the default condition against which synthetic content is defined. Rarely is it is authentic actually defined. So what is it to be authentic? There's the technical meaning, which according to NIST cybersecurity definition is this, quote, authenticity is the property of data that originates from its claimed source, end quote. So it's unaltered. But NIST also recognizes a broader normative or socio-technical meaning. Quote, it can also mean being genuine, able to be verified and trusted, or having confidence in the validity of a message or its originator. Social media policies, too, which is, I think, have been using this term authentic for a while, they too mix the descriptive and the normative. Authentic connotes real or human-made. Authentic accounts are associated with real people using their real names. Facebook polices the, quote, authentic identity of account holders, removing bot or sock puppet accounts, supposedly. And the content monetization policies of TikTok, Meta, YouTube, and the rest equate authenticity with originating with the account holder, with being genuine and original in some sense. Meta gets more subjective when it says, quote, being a creator means showing the world something relatable and real, in other words, authentic. So the relationship between real and true is unexamined, but as NIST notes, authenticity to many denotes trustworthiness, and this is a problem. Disclosure policies default to authenticity in that unlabeled content is presumptively authentic. In some sense, this is continuous with how we've thought about text since the advent of the printing press, that there's authoritative text captured in the edition. But then, before then, the text of a document varied according to the scribe. And one wonders whether that time of inconstancy in the text has come again. Disclosure policies default to authenticity in that unlabeled content is presumptively authentic, and in some sense, I've already done that, okay. Okay, so let's turn to risks. In a sense, I fear what's happening with these interventions around disclosure is that deepfakes are becoming the new fake news that emerged around 2015, 2016, and was quickly weaponized to accelerate the epistemic uncertainty that the term was meant to critique. Let me turn to two basic concerns about synthetic content mandated synthetic content disclosure. I'm going to put to the side another concern, which is really about the technical vulnerabilities of these methods. Labels are easily removed, provenance can be incomplete or faked, and watermarks can be stripped out. Because I think to the extent that we're talking about any technical tool, we're always going to be talking about an arms race against malicious actors and applications. So instead, let me focus on the conceptual fragility at the heart of synthetic content definitions and this default. Content can be mixed, it can be synthetic and deceptive, it can be synthetic and false, but trivially so, or a parody or a commentary. It can be authentic and deceptive. And so this complexity means that definitions are likely to be over-inclusive with false positives or under-inclusive with false negatives. and also lead to misinterpretation about the meaning of the default. And to the extent the obligations fall on intermediaries, there's another problem, which is the risk of further empowering powerful platforms to make content-based decisions. These problems then create legal fragility in terms of First Amendment and other free speech laws around the world. The operative definition of synthetic content as AI-made or altered is incoherent. What lawmakers are thinking about clearly is Gen AI output. Now, even there, it may not be fully synthetic, but let's just assume it is. For argument's sake, that Gen AI output may not be realistic, in which case it may impose harms, dignitary, economic, but the discourse harms are going to be mild. And then moving to the left, there's a spectrum from Copilot or other AI enhancements to old-fashioned editing, which the EU AI Act seeks to exclude from synthetic content, but without precision. So it's reasonable to expect that soon most content will have AI contributions, and the synthetic content definitions really have no ability to deal with this. They imagine at the end of the left side that there is such a thing as pure authentic content, which let's just say is faithful capture of ground reality, ground truth, like the selfie. And yet even the selfie can be altered at the source rather than in post-production. So this photo on the top places the person with the red pants next to two others they weren't actually next to at the time, using the reimagine function of the new Google Pixel. Is that synthetic content? Whose responsibility should it be to watermark or otherwise label it? Google's Isaac Reynolds contests that this is synthetic. Right? He says it's actually more authentic to the individual's perspective than is ground truth. If the disclosure requirement takes too expansive of a view of synthetic content, then you're going to get false positives. This Harris campaign photo on the right was altered, but you can see in comparison to the AP one on the left, it's not materially deceptive. If too much is labeled, you get information overload for consumers, what's sometimes been called disclosure blindness. Labels are designed to combat the liar's dividend, to tell the public what is actually synthetic, so the liar can't claim that everything is fake, but a labeling regime that is too inclusive can actually grow the liar's dividend. Things that aren't labeled are presumptively authentic, though they may not be, and things that are synthetic and full or in part, but not false, are cast into doubt. One way to deal with this is to narrow the definition of actionable synthetic content to that which is deceptive or even intentionally deceptive. And this is what a lot of the proposals and enacted laws do. I'll just give you one example. This is from the proposed Protect Election from Deceptive AI Act. Inauthentic, it requires labels for generated inauthentic image, audio, or video that appears to be authentic. And there are various other ways of getting at this deception. So this narrowing helps to limit false positives, perhaps at the expense of more false negatives, but it creates another problem. The regulated parties, usually the intermediary distributor, sometimes the Gen AI model, have to assess ex ante what will be deceptive. And then to the extent that there's a mens rea or intent added to this, it becomes less scalable, more complicated to implement, and more resistant to enforcement. And just to show, one wrinkle, this MAGA Taylor Swift, is this understood by the reasonable person to have been a parody or not? She was concerned that it wasn't, and that's why she said she had to authenticate herself and come out endorsing Harris. These scoping problems become First Amendment problems because, in general, synthetic content labeling requirement is a content-based intervention. So a law that fails to limit synthetic content disclosures to deceptive uses is likely to be overbroad. A law that limits disclosures to deceptive content also has First Amendment problems. While dispelling deception is an acceptable reason, usually, for compelling speech, entities will argue that the standard is too vague. And we know from the recent decisions about internet age-appropriate design laws that courts are skeptical of forcing companies to take action on the basis of judgments about content harms. I'm going to just go really quickly through this. I mean, I think this problem of narrow tailoring to if the government interest is in preventing deception, then the fact that a lot of authentic content, I think someone mentioned here in Ohio the group libel against immigrants. That doesn't have to be synthetic to be deceptive. An authentic photo of an immigrant with a goose, for example, that is miscaptioned is authentic and deceptive and would not be covered by these labeling requirements. And I think, sort of more fundamentally, this focus on bits of content completely misses the critical function of amplification, which may be more central to the dynamic of deception than any particular feature of the underlying content. Okay, so an alternative to, I'm closing with this, an alternative to defaulting to authenticity is defaulting to distrust. Might we have to resign ourselves to a world in which, for the near term, as the storm gathers, authenticity cannot be the default? Recall that the AIEO directed the federal government to focus not just on disclosure and synthetic content detection, but also on authentication tools. This is where I think policy energy needs to be directed. There are, C2PA is one of a number of open standards which are creating these provenance records, a sort of chain of title. And so where the policy intervention is important is that when you have content creators who want to authenticate content, and that's going to be in situations where it's important for them to do so, which is going to be where there are strong economic, electoral, discursive interests at stake. When they want to authenticate content, you're going to need to have the AI model and the intermediary respect that provenance information and pass it through. And so there has been proposals to require them to do this. This California's AB 3211 is one I mentioned. I'm going to skip that. And there's federal proposed laws that would do that too. What I'm going to close with is that I'm sympathetic to this push for synthetic content labels because they do, in some sense, what is familiar from analog disclosures, especially in the electioneering space. But interestingly, the work of the I approve this message that we know from broadcast ads was actually to default to distrust and lift up messages the candidate is actually, that are actually attributable to the candidate. And I think authentication is closer to that. The equivalent of the label is the authentication process and the digital manifest that policy interventions should support. No, that's with that.
Should you want me up there too?
You have to go to the podium.
It's the downside of not giving the moderator a seat. Thank you, everyone. Your presentations have all been wonderful, and I'm sure have given a lot of food for thought for our audience members. Given the range of topics that even our group has covered, I wanted to focus on kind of a more general idea here. And that is, to the extent that we're talking about artificial intelligence or generative AI, we're talking about it in two senses, right? One, it has the benefit of making falsity more believable. The lie that we wouldn't perhaps have doubted quite readily, one that we're much more willing to accept. And the other is that it makes it more available, right? So the fact that we are now sending, it doesn't even have to be generated, but just a falsehood that's now available to millions of people instantaneously. So to the extent that we are concerned about this and using defamation as a tool, it strikes me that we're running into the problem not so much as proving authenticity, proving source, or reliability, but bursting the bubbles of worlds in which different audience members have different realities. Right? And in the past, when we're relying on defamation, the primary concern was to remedy the individual whose world was destroyed by the falsity. And even if it didn't change the discourse, it might very well provide an important remedy, recognition of their autonomy, as well as financial compensation. Should there be, if you're looking at this information ecosystem and the concerns about discourse, if you had to pick one priority, right, from each of you, what would it be? I will open it up for your discussion.
Well, I guess I hope this is responsive to your question. I think one thing that has to be done, one distinction that has to be made, when you talk about bursting the bubble of separate realities, there are some respects in which we do all live with separate realities, and we even have a right to separate reality. There is a sense in which religious liberty entails a right to separate realities, and those separate realities have value for people. And I think that's not just about religious liberty. That bleeds over into having certain beliefs. And so the question then is, where do we need to have a shared understanding of certain facts in the world, right? Hopefully we have an identical, a relatively similar understanding of our sensory perceptions line up, hopefully, when we look around. But then when we talk about just understanding the facts, where do we need that? And I guess sort of one of the benefits of focusing on election law is that there's some certain kind of consensus that a democracy needs. That's in those respects, the law has to respond to that, or where reputations can't be falsified. But I guess the last thing I'll say is it really shouldn't be an excuse, though, for government or some other very powerful entity to try to impose consensus that's not needed on everything.
It's a hard question. Of course, the role of public discourse is in part to help us find shared consensus, and due to some defects in that discourse, perhaps we're having trouble finding the consensus. I guess lately I've been thinking about the biggest crisis is the crisis of legitimacy in our core public institutions, and I write a lot about the press, as does Ronell, and so that one's one that concerns me tremendously. But lately I'm incredibly concerned about faith in the judicial system and faith in the judiciary, and without that, none of these legal tools are going to create the preconditions for democratic self-governance. So I guess of all the things that I discussed, somehow reinstilling faith in our institutions, partly by our institutional actors being trustworthy and committing to adherence to customary norms of behavior, not just the absolute rules and the minimum of the rules, but it's been shocking to discover how much people not adhering to customary ethical norms is undermining journalism, undermining the judiciary, undermining democracy.
I guess if this is sort of the genie question, right, or the magic wand question, like you get one wish, what do you pick for? And so I'd like to start with, I wish for 3 more wishes. But I think that the core overarching thing that strikes me as a top priority is shared civic education, and I mean that in a broad umbrella term. I clerked for Justice O'Connor at the very tail end of her time on the court, and so she was making not specific but broad retirement plans at the time that I was in her chambers. And I look back on it, and I think a bunch of us she was talking about how she was going to go all in and sort of make it her mission post-retirement to highlight civic education and shared communication across the country about how government works and how communications work, even sort of the sorts of things that Ellen was talking about, just sort of making sure not just that we have these laws and proposals, but that everyone understands the existence of these laws, like sort of media literacy kinds of conversations, how a free press works, how the rule of law works, how a jury verdict works. And a lot of us who were at the court at the time and talking to her, we thought of it as very small potatoes, right? Sort of disappointing and quaint, and not what this person who was the most powerful person in the federal judiciary like really should be doing with the clout that the capital she was leaving the court with. And I look back on it now and think that she was just an absolute prophetess, right? That she saw that the failure of those shared norms, those shared constitutional, like lowercase d democratic values, matter. And she talked all the time about learning to disagree about what to do about the facts, but at least understanding that there are shared facts in a democracy. And I think that strikes me as really important. A lot of her efforts were focused on front-end middle schoolers, right? Sort of raising up a generation of people who understand it, and I think that's going to be critical. I think we should value civic and media education in big ways and talk about the ways that they interact. A lot of the data, unfortunately, shows us that the biggest problems that exist today is not that generation, but rather like my Uncle Russ on Facebook. Surely a big piece of the problem is that people who, we're dealing with this moment where something that will one day be old technology is new, right? This is the moment and so they are thinking Walter Cronkite, but what they are getting is Uncle Russ. And they aren't distinguishing and I doubt seriously that there will be easy or quick ways to communicate the way that the world works to a lot of people who are having really important conversations about how the world works with each other. So I guess that would be like if you gave me the magic wand, I would tap everyone and give them that shared civic and media literacy education that would allow us to start having the much harder conversations that are still going to be very, very difficult, but at least they could come from a place of shared understanding about what's trustworthy and what's not, and what questions should be asked and what shouldn't, and how to connect the dots between A and B, such that we can have the really hard conversations about what to do about the facts, while not having to have the hard conversations about what the facts are.
Okay. I want to reduce income inequality, and I want national service. Because I think in line with what everyone is saying is that these problems are kind of upstream of like media and information. And I think Jill Lepore, the historian, did great work on kind of, in the aftermath of World War II, there was sort of this American panic about, fascism and on sort of an interest in what are the bones and sinews and muscles of democratic practice. Not so much institutions; those are part of it, but just democratic practice. And in that period, there started to be lots of sponsorship of like school debates and civic education and all of that. And it was a very intentional, flourishing at all levels in this area at all levels of. In that case, it was governments, it was corporations, it was foundations, and there was just a really concerted effort and a very self-conscious commitment to kind of developing democratic practice. And I think some of those things, it was also a period where there was much less income inequality and a much larger middle class, and I don't think that can be underestimated about sort of the effects of these kinds of, it's not just political polarization, but polarization in the way people are living, creates siloed realities. So those would be my two interventions.
Open up to audience.
This incredibly thought-provoking, and I particularly love Ray's first question because it provides a great jumping-off point, I think, for mine, which is I wonder how much we, the five of us, are suffering from the privilege of age, by which I mean we exist in our lifetime in a time when there was a concept of truth about which I think we are all nostalgic. And I think that as we talk about sort of how we might want to move to a default of distrust, we might be looking past the fact that most of the people in this room default to distrust already. And that leads to disaffection. And disaffection leads to the sort of defamation litigation as theater that we're seeing and various things like that. Ethan Zuckerman in his book Mistrust talks about how this might lead to the sort of seeds of social movements, of positive social movements. I'm not sure I share his optimism, but what do you think, right? Are there ways that the disaffected can build institutions or build trust in institutions that will lead to the kind of value and trust that we're nostalgic for, or is that a hopeless cause?
Well, here's one thought. First of all, thank you for that phrase, the privilege of age. That's going to make me feel much better. Feels stiffer, maybe. But so here's one thought, anyway, partial thought. If part of the problem is silos of assertives, at least one possible solution, unfortunately, doesn't seem to be working in any of the venues I look at, is to try to create institutions that can convince various people that they actually are welcoming across those silos. Now, obviously, that's not the way that, say, modern political parties are working, or many other groups. But that would be a way. So it's sort of partial surrender, because if you think that in certain silos they have it completely wrong, then if you tell them that, you're not really appealing to them, right? So if it's sort of like the concept is sort of like overlapping consensus, or some concepts that sort of play a role for many liberal theorists, right? John Rawls speaks about different comprehensive views as being being able to accept a more general political structure as a module, if I'm remembering that correctly. And so that's just one thought.
In a way, I don't think of myself as an expert on this in particular, but I do, I've long believed in the power of discourse, but when we stop being able to have discourse, we may not be able to talk to each other, but we appear to be able to shoot each other. And, too much disaffection eventually leads to revolution, potentially. So I certainly hope and if you read history, I think it gives you both pessimism and optimism. Optimism in the sense that there are, pendulum swings throughout history, and we happen to be in a highly polarized swing, but perhaps we can swing back again without revolution. I don't have a good answer.
Yeah, I mean, a big piece of the complexity that I see here, my primary day job is that I am a press freedom scholar. I write about protecting the press and argue for protections for news gatherers, both old school news gatherers, and I'm trying to think about evergreen doctrine that we can build that will make sure that we ensure democracy enhancing news gathering even as old legacy media institutions die. And one of the things that I am constantly facing is this notion, this tension that I think that we're all articulating here, which is I would like to amplify and rebuild trust in important democracy-enhancing institutions. So primarily the press, but also the courts and elected branches and academia, right, and science, right? There are knowledge institutions, and the declining trust in knowledge institutions makes me nervous for the health of our democracy. But I'm nervous about, I don't want us to all start trusting those institutions blindly. I actually have a pretty serious concern that among the reasons that we have diminished trust in those institutions is that they are acting in less trustworthy ways. And so figuring out how to have a very sophisticated conversation that simultaneously builds institutions that are worthy of trust, that are tools that disaffected members of the population can rely upon and can see reflected in them. Just to give the example, last year, I spent the whole academic year at the Knight First Amendment Institute at Columbia with my co-author talking about rebuilding trust in the press. And among the workshops that we hosted were workshops that talked about the failings of legacy media to represent views of underprivileged and underrepresented and minority groups. And right, that's a very different conversation. That's not about everyone, please, like convince everyone that people who are performing the press function are trustworthy. It's rather remedy performers of the press function so that they are telling the stories of everyone in a democracy such that they're worthy of trust. And I think that we need to be working on it. It doesn't have to be binary. This can be a front end and a back end solution at the same time. And I think proceeding with like some cognizance of that is really important.
I'll just jump in with just one suggestion. I think that the universities moving to these statements of neutrality is very positive. And I think that, universities have lost a lot of credibility as sort of epistemically neutral and trustworthy places because they have not been neutral and not been welcoming to all views in places where people can sort of hash things out. So I think that's a really good step. And I know, and Renelle, and I've really struggled with this in journalism and press because there was the move from sort of objectivity to throwing objectivity out the window to, and I think that it was both impossible and undesirable. And I actually have always wondered if that was a good idea and if objectivity, some notion as phantom as it may be, at least the aspiration towards objectivity and neutrality. Obviously, courts, have to strive to that. I think the more institutions we have that do the hard work of trying to be neutral and neutral platforms is really important.
Thank you. And I know I had it at 3 p.m., so if people need to leave, that's totally okay, but I do not have 15 minutes of closing remarks. So if we want to continue with questions for a few more minutes, we definitely can if the presenters are all right with that. Perfect, okay.
So this is a question for Professor Jones. Dominion versus Fox settled the day they were going to go to trial, but there had already been very damning findings by that judge. Do you think there would be anything that we would have discovered if it had actually gone to trial that we don't know now?
Yes.
And do you have any
it was happening. I had actually asked my husband as a birthday present for a plane ticket to Wilmington, Delaware, because that's the degree of nerd that you're staring at. I mean, the witness list included Tucker Carlson and Rupert Murdoch. So we had snippets of materials that had been gained in discovery, and they were quite telling snippets. But it was also, in some respects, a more complicated story than a lot of people were giving it credit for, because actual malice requires that you show that the individuals who are responsible for producing the particular lie knew of its falsity, not generally that there were people in the Fox News organization that had knowledge of that. So the connecting of the dots between the production of the falsehood and the generalized knowledge that the election was not stolen was the thing that the lawyers were tasked with doing there. Just to sort of say the quiet part out loud, this is another reason why we can't rely on defamation law to be our pure solver of all disinformation that swirls around elections. Dominion has an obligation to its shareholders. It's a company that has to make decisions and litigation strategies that are rooted in some calculus about their odds. And juries are unpredictable beasts, and you go before a jury and you don't know for sure, you can't tell 100% what's going to get said on the stand, or how the mix of jurors is going to feel about a standard like knowing falsity, right? Whether you're going to be able to prove that up. I actually think that got litigated. The truth is, I was surprised that it didn't settle sooner, right? Than it did, and I think it was because the folks at Dominion made a calculated decision that getting this body of evidence together at the motion for summary judgment stage and making it public would have meaningful impact in correcting the public discourse. Now, whether it did or not, I mean, I think Larissa and I noodle on that all the time in the middle of the night, staring at the ceiling. But the point is that it shows us both a real strength of this and a real limitation. For sure, we were prepped to find out more information. September 30th, Newsmax versus Smartmatic, actually Smartmatic versus Newsmax goes to trial. So that's the next, it's the only of the remaining suits that we'll have before the next election. And I think we're gonna get a lot of the same kind of content if it moves and doesn't settle.
You.
Okay, first,
Waiting, but sort it out amongst yourselves.
triggered by the last question, I think I want to editorialize very quickly. I think the privilege was not the age of us and enjoying the truth. I think the privilege was the people who used to be shielded from the misuse of the truth are now more and more subject to manipulation and lies. I can tell you as a gay man, when I first became a lawyer, that was during the height of AIDS. And everything I heard was, I was an evil person, I was going to pollute the world, I was going to kill people, et cetera, et cetera, et cetera. And that is sort of the same standard of mistruth that white majority is facing now, straight white people, that they didn't have to deal with before. So I think part of it is, unfortunately, the start of the mistruths was ignored by the majority of our population back when it happened. My question is, I'm wondering if this is a time to introduce a sort of a sliding scale of defamation based upon the power you have, the incentive you have, so that those who can profit from it and want to profit from it are going to be held to a higher standard than those who are the Uncle Teds who just post things on Facebook.
Sure.
I mean, right now we seem to.
As long as I've already defamed him,
Yeah.
we might as well just go all on. I'm an undeterred defamer. Yeah, there definitely are proposals that already have been floated, and in fact have been floated before the United States Supreme Court in a previous generation about having defamation, constitutional defamation standards not rise and fall on the plaintiff's status, but rather on the defendant's status, right? The character of the defendant. And that could work in a bunch of different directions. It could work in the direction that you're describing, that we hold certain entities to higher standards, or we probe their motivations in particular ways. It could also be a mechanism by which we single out some entities that count as the press for greater protection only if they behaved in what we think of as constitutionally appropriate press-like ways. It's not a path we've traveled down, but it's one that lots of us are interested in talking about.
Hi. I have a question, more so I think for Professor Goodman. I just wanted to challenge this idea a little bit of defaulting to distrust, and just see if you could kind of round out that concept a little bit for me. Just to piggyback on what Professor Rosenblatt said, I think my generation is extremely distrustful, especially of our institutions. I think at the very least we have like a healthy skepticism. So I'm just wondering if defaulting to distrust in our legal framework is the right answer, right? We were talking about how the law, is a reflection of our morals, and we have moral decisions made by judges, right? So if we have this default of distrust in our laws, it just seems like maybe we're enshrining the distrust that's in our society right now in our legal framework, and that maybe doesn't necessarily feel like the right answer to recognize that and to enshrine that in our laws, that we're defaulting to distrust instead of authenticity and maybe like a healthy skepticism?
So I'm not sure what the difference is between healthy skepticism and defaulting to distrust. But so what I'm talking about is the media environment and whether there should be what sort of interventions should happen there. I think in terms of our laws, like in the way the laws apply, we sort of already default to distrust, right? We have ways of authenticating. You have to authenticate documents, and they're not assumed. You have to authenticate chain of title. We have lots and lots of areas in which the things have to be proven, right? And in our discursive environment, we haven't had that. And so, and what the synthetic content disclosure interventions, which sort of are the coin of the realm right now in terms of the interface between at the sort of burgeoning of trustworthy AI policy, what I'm calling into question is whether recognizing the reality that those solutions will not scale. So I am not saying give in to distrust and sort of, it's not a counsel of despair. It's about what are the things we need to build. How do you build trust? And so I'm just suggesting, and by the way, I didn't start out here. This has been the end of after 2 years of sort of working on these policies and being very much like label, watermark, that's the solution. I've just come to this conclusion that it actually could be quite dangerous. And that instead what we need to work on is, kind of in the spirit of the first question about what are the things we need to build to reconceive of how we can build trust. And so it's really about building. Here I talked about authentication. There are other kinds of institutions that are wraparound institutions that have to be built around to actually, consume that authentication and build meaning from it.
Thank you.
So I would love to come at this from a slightly different angle that I think tags to the last question and sort of has an arc that I want to encourage the panel to challenge an assumption, right? Democracies work because, at least in theory, we all get to be independent, autonomous agents within the political community and have discourse with each other. We can, and importantly, from the First Amendment perspective, I mean, I'm just a poor country election law scholar, but your fancy First Amendment folks tell me, right, the marketplace of ideas is such that I can take an idea, assess it, act as a political creature according to it, and then defamation, at least so the theory goes, allows me to create a disincentive for lies, right? And then there's that space of, as we have talked about all day, some lies we have to tolerate because it's political discourse that ain't harming nobody. I have skepticism about that. But here's the thing. The story I've heard from this panel is one of all those mechanisms, all those assumptions are deeply fraught in the AI age, which leaves me with the question of how is that conception of democracy set up by the marketplace of ideas supposed to work? So, and so my question is, do we have a romanticism about the marketplace of ideas conception? And if we do, then if we're building something new, what that ought to be? And you have 2 minutes to answer.
Well, I've written before that the marketplace of ideas is built on a romanticism about various human qualities. And one of them is that we're reasonable actors and can see our own good. And the other is that more information is always better than less. And we know from some cognitive research that sometimes more information can lead to information overload, decision paralysis, and worse decision making. And I think technology is a piece of that story about this flood of information, it sounds great, right? And the First Amendment says more is always better, more is always better. But we're discovering in terms of all of the things we want from the First Amendment in democratic self-governance, more is not necessarily always better. And then the assumptions about human rationality, all the literature on cognitive biases suggests we're not always rational, especially when presented with this influx of undue amounts of information. I've argued that we need to assume we're rational anyway, or else the government, has too much. I strongly distrust the government. There's two reasons in First Amendment theory to distrust the government. One is that you think they might be tyrants, that they have an incentive to stay in power and be tyrants. The other is that they're fallible. I tend to be on the fallibility side of distrust. But nonetheless, you have to maintain this fiction that we are, as citizens, are rational and can make use of information. I don't think you have to assume the more is better. I don't know if that answered your question, but it was 2 minutes, maybe.
I mean, this is one of the reasons why I have argued that performers of the press function ought to have heightened constitutional rights, because they help us to do those tasks that we lack. We cannot rationally process the entirety of the world of information. We cannot rationally go to every court proceeding. We cannot rationally contextualize and say, this is the third murder in that neighborhood this year. And performers of that function are central to democracy, and I think that they have that theory it has always been the case that the marketplace of ideas is a flawed theory, in the sense that it expects all of us to process the whole of the world of information. And so figuring out ways that we can build tools constitutionally to protect the performers of that function is a top priority for me.
Awesome. I think that closes off the symposium. I want to give a round of applause first for Professor Teresa moderating this panel. And then an even longer round of applause for all of our speakers. This panel, the last panel, keynote, it was amazing to hear from everyone. And we're very gracious to be able to come here and celebrate with us. Even if there's all this distrust, delusion, with 1 month left, it seems like the call to action of today is just go vote, right? That's the most important thing, I guess, that I got from all of this. So I really appreciate everybody coming. If you're interested in still keeping up with these speakers, I'm sure they will be publishing lots of different papers and in the media in the next month, a lot. And we'll be publishing a few different papers from this symposium that should come out in late 2025.
Huge thanks to Andrew for organizing and bringing us all together.